Welcome back to Courtroom Chronicles, where justice meets reality. Today, we're diving into State of Texas versus Lisa Telsey. What starts as a routine courtroom exchange soon reveals the weight of choices, consequences, and truth under oath. Let's see how this hearing unfolds and whether remorse can truly outweigh responsibility.
Please announce for the record for the state.
Marcus Sanders.
For the defense.
David A. Garcia, attorney for the defendant.
All right, and if you're Mr. Pena, could you please unmute for me, please? Did you understand the state is proceeding on count one, that's possession with intent to deliver a controlled substance, penalty group one, penalty group one, 4 to 200 grams. That's a first degree felony. Range of punishment is anywhere from 5 to 99 years of life in prison and up to a $10,000 fine. Did you understand?
Right here. The judge begins by confirming the defendant's understanding of her legal rights and the court's admonition. It might sound procedural, but this step ensures Lisa can't later claim she didn't understand her plea or the charges. Every yes and no in this phase matters. It locks her statements into the record permanently.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Did you understand, according to the plea bargain agreement, the state is proceeding on count one only? They're asking for a $0 fine. They're recommending deferred adjudication. There's restitution of $1,500 to Jovan Garcia. Did you understand that to be the plea bargain agreement, Mr. Pena?
Yes, Your Honor.
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 120 hours of community service to restitution. 120 hours of community service restitution and restitution for drug testing. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Opinion to the offenses charged in count one. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, Judge. The state offers States Exhibit 1 and its attachments.
Listen closely. The judge's tone stays calm, yet firm. This isn't casual conversation. It's structured accountability. Many defendants get nervous here, but Lisa seems composed. It's moments like these where you can tell whether someone has accepted the reality of what's about to happen, or is just hoping to get it over with.
We've reviewed States 1 and all attachments, Your Honor. We have no objections.
Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, I've spoken to him. He understands he made a mistake and he's looking forward to prove himself. We're hoping you give him this opportunity to attempt and complete the deferred adjudication offer.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 5, and 6.
Same mother?
Yes, ma'am.
And where are they?
With their grandma.
All right. So I'm assuming they're with the grandmother because the mother is not taking care of them, correct?
Yes, ma'am.
And you're not taking care of them. So what's your drug of choice and what's the children's mother's drug of choice?
Heroin.
All right. And is Child Protective Services involved?
Yeah, that's why they're with the grandma.
Yeah. Okay. How often do you use heroin?
How often?
I'm sorry?
How?
When the court references affidavit of admonitions and defendant's waivers, that's a big deal. Essentially, Lisa is acknowledging she's aware of her rights, including the right to a jury trial, and is voluntarily waiving them. If she agrees here, she can't go back later claiming coercion or confusion. It's legal precision wrapped in emotionless formality.
Often?
Yes. How often?
When I was out there, I would do it every day.
So we're going to have to get you into shape mentally, physically, emotionally, so that you can take care of your children and not be riding around with these 3 people who are family friends. And I'm sure they use drugs as well, riding around with them instead of doing what you need to do for Child Protective Services in order to get your children back. Are you associated with any gangs or no?
No, ma'am.
When's the last time you had a full-time job?
No, I don't work.
I'm sorry, what?
I don't work.
Why don't you work?
I get a government check
For what?
for disability.
For what?
For disability,
What's your disability?
slow learner.
All right. There are a lot of people who are slow learners, but you brought 3 children into this world. So somebody has to support them. And the person who has to support those children should not be taxpayer, but that's your job. It should not be the taxpayer's job to take care of children that you brought into.
You can feel the shift. Lisa's responses get shorter, more hesitant. That's often when the weight of it hits. Facing a courtroom isn't just about guilt or innocence. It's about standing before authority and admitting, in public, that your actions have consequences. The human side of justice can be heavier than any sentence.
To the world who are 4, 5, and 6. Okay?
Okay.
Okay. There's going to be 6 years deferred adjudication, $0 fine. See if we're going to try SATA. If SATA says no, then it will be SAFE. So proof of employment or SSI within 30 days of release. All right, Mr. Pena, is there anything else you need from the court in order to be successful? All right, we can go off the record. Mr. Pena, I think you can do this. However, whether or not you're successful at it, gonna depend 100% on you. You understand?
Yes, ma'am.
And, people say, you shouldn't say that, but somebody needs to tell you and it needs to be said. It is easy to be fruitful and multiply. But let me just tell you, children cannot support themselves. You can't have a 5-year-old, 6-year-old, 7-year-old, put them out on Travis Park and tell them, go forth, I've done my duty. They depend on you as an adult. If you can't take care of your 5, 6, 7-year-old, you need to wait until you get yourself together. You're clean and sober. You have employment and you're able to financially support your children financially, emotionally, and physically before you think about continuing to be fruitful and multiply. You understand?
Yes, ma'am.
All right. Good luck to you, Mr. Pena. So this was previously set for a hearing on July 31st, and he left and never returned.
That's my understanding, Judge.
All right.
Now pay attention. This is the kind of exchange viewers often miss. The judge isn't just verifying facts. He's ensuring there's no loophole left open for appeal. Every courtroom phrase, from "for the record" to "do you understand," builds an airtight transcript. Do you think Lisa fully grasped what she was agreeing to? Or was she just saying what needed to be said?
I was also not the attorney at the time.
So first things first, is this going to end up being a contested?
We don't have an agreement right now. I mean, obviously, our goal is going to be to try to work it out. But Mr. Pena has been very actively working services with CPS and being tested through them. And there's a lot of material I need through that apparatus to bring to the court that I think would be helpful for the court's understanding. And so obviously I'm gonna need some time to get that done. I just got hired over the weekend.
Okay. So how much time do y'all need for a contested? What date?
I'd ask for approximately 30 days, Judge.
Okay, I'm not going to give you all 30 days. He's been gone since July of 2023.
Yes, Judge.
So, state,
Yes, Judge.
how long would it take you to have your witnesses?
Not long, Judge. It shouldn't be, if I believe correctly, shouldn't take that long.
All right, so the week of October 28th?
That should be more than enough time. Judge.
All right. Ms. Ferguson, if you'll put this down for October 31st. And I'll put it down as a contested. If it's not a contested, you all just let me know.
I understand, Judge.
All right. Now, the next thing, defense has filed a motion for a bond. Is that correct?
That's correct.
And he's entitled to one based upon the fact that he's on deferred adjudication. Have you all had a chance to confer on a bond amount?
Judge, we haven't had a chance to confer. I don't believe we're in agreement.
All right. Do you all want to confer on a bond amount?
Judge, we've conferred on it.
Oh,
And,
okay.
and so Mr. Pena's very much in need of getting out. He's involved in the CPS case, like I've told the court. He's been working services. He's been taking his classes. There is a final trial on the merits on Thursday. We're trying to get him available for that. I know that, I mean, obviously it's hard for me to come here and say, Judge, don't worry about it, he'll be here, because he didn't show you that before. But I think the fact that he's been working through that system and staying clean and participating in that, and what CPS has asked him to do, and I've got,
But is he clean because he's in custody?
our contention is he'd be clean even if he wasn't in custody, Judge, and we've got a certificate from his parenting classes.
Any objection to the
No.
court meetings?
And so obviously he's clean right now, Judge. Obviously he's in custody. What he contends to me,
And that wraps up another real courtroom moment, the state of Texas versus Lisa Telsey. A reminder that, in law, silence isn't safety, it's acceptance. Every response carries weight. What do you think? Was Lisa truly ready to face the outcome, or just hoping the process would end quickly? Drop your thoughts below, and don't forget to subscribe, like, and share for more courtroom breakdowns that bring truth into focus.
is that even if you weren't in custody, he'd be clean because he's trying to stay in compliance with CPS. So to that end, Judge, I'm asking the court to set a bond. The last bond he had in this case was $15,000. I'd ask for something around that amount. The family doesn't have all the money in the world.
You want to call your client as a witness with regards to bond amount?
Sure.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense?
So Brandon, you guys know what, you understand how bonds work, right? You're paying 10% of whatever the bond premium is. Okay, so the judge were to set a bond, for example, the last one was $15,000. You'd have to pay approximately $1,500 to get out. You understand that? Yes. Okay. Now, do you, to the best of your knowledge, does your family have, let's say, $15,000 or $10,000 that they can pay for a bond?
My family don't have enough money.
Okay, he said his family don't have much money.
That's correct.
Okay.
Do you believe that your family can come up with about $1,000 to get you out?
Yes, sir, they can come over with them.
Okay. Do you believe that they'd be able to come up with significantly more than that?
No, no more than that.
Okay, speak clearly, speak slowly.
Yeah, $1,000 they can probably come up with.
So are you asking this court to set a bond somewhere around $10,000 for you in this case?
Yes, sir.
Okay, you understand that you've been gone before, right?
Yes, sir.
Oh, you understand that's going to be taken into consideration when the bond is set.
Yes, sir.
Are you working right now? Well, where were you working before you got picked up?
Yeah, I'm working with my brother. He owns his own business, cutting trees.
Okay, so you cut trees. But approximately how much do you make cutting trees? Approximately.
Per day, like 125.
So maybe 100 to 125 a day. How many days a week were you working?
5 days out of the week.
Okay.
All right, any questions?
Yes, how many times have you gotten bond before where you later never showed up to court?
Just one time.
So you previously have been given a bond and then you never showed up to your next court date. Is that correct?
Yes, sir.
Nothing from the state judge.
All right, so how much are you asking for defense in a bond?
Judge, the last one was 15. The family, I think, could be able to hire a bondsman and, somewhere in the $15,000, $20,000 range. If the bondsman will take 5% up front, which they usually will. So that's what I'm asking the court to do, is to consider something in the $15,000 to $20,000 range, with weekly ways and weekly reporting.
All right, state, what are you requesting?
The judge state's asking for $40,000. There have been previous times where he's not reported after getting a bond. Again, that's been a recurring issue in this case. We also ask for GPS, partial if you have work, and weekly reporting to make sure that he's staying on track.
All right, the court set your bond at $15,000, partial GPS, waive fees, and it's for employment only. And of course, I will put in for also all court settings.
Yes, Judge. No,
Is there anything else?
Judge, my concern is, sometimes even when we post bond, if there's a GPS hold, they don't get released until there's a GPS available for them.
Oh, there should be one.
That it's just been my experience, Judge, that can certainly be a holdup.
If there isn't, let the court know and we'll take care of it.
Okay.
All right.
Thank you so much.
All right, thank you. Norma, if you can give him a reset form to make sure he has it. here on Brandon Rocky Pena. Randy Rocky Pena.
He's not.
Okay,
Pretrial services indicating that he removed his GPS device.
okay, all right, we'll go on the record.
So I didn't expect him here.
Okay. All right, court is calling 2020 CR 1209, State of Texas versus Brandon Rocky Pena. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Louis Martinez on behalf of Mr. Binion.
All right, this hearing was scheduled at 9 a.m. It's now 12:05 p.m. Your client has not made an appearance. Where is your client?
Judge, I don't know. I've gone through his family and his girlfriend to find him. I've gotten no responses from him. So it is altogether not surprising to me that he's not here, but I will continue to try to get a hold of him.
All right, state.
Judge, I don't know if we're asking for a bond forfeiture or.
Yes, bond forfeiture.
And Judge, there's a judge's warrant in place right now, and I don't know if we can just.
Oh,
increase
judge,
the bond.
there's a judge's warrant.
Yes.
For, all right, so I'll keep the judge's warrant in place and remand him without bond.
Yes, ma'am. Thank you.
All right, thank you. 20 CR 1209, State versus Brandon Rocky Pena. Could I have parties announced for the record for the state? Defense?
Louis Martinez on behalf of Brandon Rocky Pena.
And are you Brandon Rocky Pena?
Yes, ma'am.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, State's motion to supplement pending motion to enter adjudication of guilt and revoke probation, and first motion to enter adjudication of guilt and revoke community supervision with your attorney? And did you understand it? Are you the same Brandon Rocky Pena who was placed on deferred adjudication in 2000 CR 1209 for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams on July 15, 2021 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
State's motion to supplement. Under the condition of 5, Enfield County, Texas, defendant Brandon Rocky Pena, defendant there failed to report to the supervision officer as directed for the months of January 2023, February 2023, March 2023, April 2023, in violation of condition number 5.
How do you plead to that? True or not true?
True. Your Honor, we waive the remaining violated condition.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court would find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to a $10,000 fine? I'm sorry?
No.
You didn't know that? All right, you want to discuss that with him?
Oh, no, we discussed, remember I told you she can give you 40 or 50 or whatever she wants, right?
Oh, yeah.
Yeah, so you're on deferred for a first degree, which means your range of punishment is from 5 years up to 99 years of life, and a fine up to $10,000. So if the judge revokes you, she doesn't give you time, she can give you as little as 5, she can give you as much as life. So that's what we discussed before, remember that?
Oh,
Okay, so do you understand that?
Yes.
Okay, and knowing that, do you still want to plead true in front of the judge and let her decide what happens?
All right. So knowing that I can sentence you up to life in prison and up to a $10,000 fine, you still wish to plead true to violation of condition number 5? All right, court will find violation of condition number 5 true. Is there a proposed agreement? All right, state, what are you requesting?
State will take consideration a case failure to ID that is cause number 2025 PF 05908.
All right, and defense, what are you requesting?
Hey, Judge, we're requesting that the court take notice of the fact that he's been in custody, assess that as a jail sanction, and place him on probation with ISP requirements and kind of a zero tolerance arrangement. That's what we're requesting the court consider.
All right, why are you not reporting?
I went to report it and they sent me to go drug test, and when I went there, the lady kept telling me that I have to go back to talk to the probation officer, and they had me like back and forth, and I couldn't because I had to talk to my brother, so it was back and forth.
All right, so I don't understand how that translates in you not reporting for months at a time.
You know, because like one time we had the first time.
No, I mean, you didn't report. The state read the allegations, and you didn't report for January 2023. You didn't report for February 2023. You didn't report in March 23. You didn't report in April 2023. And here we are in 2025. So since April 2023, have you reported?
Oh,
So that means you were missing the entire year of 2024. Is that correct?
Correct.
All right, so yeah, I'm gonna find you guilty. And I'm going to grant the motion to revoke. Does anyone want to speak to time? State,
Yes, Your Honor, the state's requesting 10 years.
all right, defense, what are you requesting?
And Judge, I don't think this is a 10-year case. Speaking to the court's decision to revoke, Mr. Pena is not out committing violent offenses. He's not assaulting people. He's not robbing people. I don't think that we as a society are safer with him locked up, and I don't think that's a proper use of the limited penitentiary time, space that we have in Texas. Because when we put nonviolent offenders in there, all that we're doing is creating pressure that's going to get violent offenders out earlier. But as a court to take notice of that. I think Mr. Pena could use some cognitive skills. I think he could use some training. I think he could use a chance to kind of figure out how to get from point A to point B in life. I think that's a productive use of the court's supervision resources. So I don't think that revoking him is going to get us where we want to be. That having been said, I know the court right now is inclined to revoke, but I don't think that Mr. Pena, if he's going to be revoked, should do more than 5 years. Don't think that it's warranted proportionally with what we see here in Bexar County on a daily basis.
All right. So I understand the defense's argument, but he's charged with possession with intent to deliver, not possession as though he's using. Possession with the intent to deliver means selling. And I'm reviewing the previous stipulations that were in place. And the drug amount wasn't one that was barely over 4 grams.
And Judge, I make no
Mhm.
assertions that that's not true. And like I said, the point that I'm trying to make is that this is not a violent offense. And as you can see, Mr. Pena is not terribly sophisticated. I don't think he was particularly good at getting away with what he was doing before, which is how he got caught. And once again, I don't believe that a lengthy prison sentence is warranted by the circumstances.
All right. Because it says in the stipulation that there was a scale for weighing narcotics. All right. Is there anything else from either side?
Nothing else. State's Your Honor.
No, Judge, not from the defense.
All right, and probation? Was the $1,500 in restitution paid to Jovan Garcia in 2021 CR 3743? Did you pay any of the restitution?
No, ma'am. None of it.
So you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. All right, what have you done since you've been on probation? Yes. So did you report to probation?
Probation, I went one time to go see you.
One time.
Yeah, one time.
All right. Did you do the UA hotline where you call in to get drug tested?
Yeah, she sent me there. So when I tell,
Did you do any community service hours?
no,
Did you complete your parenting classes? Did he complete parenting?
I did something.
No, ma'am. There's no record of it.
All right. They don't have any record of you completing parenting classes. Did you complete parenting classes? I'm sorry?
It's not.
No, I mean, either you did or you didn't. You will remember taking parenting classes. Did you take parenting classes? I'm sorry?
I'm not.
Then why would you tell me you had taken them if you didn't? All right,
Judge, I would like to point out that he did go to SafeP and completed that.
okay. All right, and did he complete the outpatient treatment with SafeP?
No, Judge, not the follow-up.
Okay. Court is gonna find you guilty, revoke, taking consideration 2025 PF 05908. There's to be restitution of $1,500 to Jovan Garcia, and the court will sentence you to 10 years in the prison, give you credit for any time served. And counsel, I'll request the therapeutic community. It doesn't increase the time that you're in custody, but if you have any drug issues, then it will help you with that.